Good afternoon. Thank you for joining us for the third and final panel in our fall 2021 virtual conference, The Road Ahead on Immigration Law, What Can the President Do? First, some logistical and bilingual points. Thank you to Ada, Enrique, Galia, and Sergio. This program will be simultaneously translated into Spanish. So if you want to hear it in Spanish, at the bottom of your screen, click the globe icon and click Spanish. Este programa será traducido simultáneamente al español, así es que por favor, si lo quieren oír en español, abajo a la derecha de su pantalla hay un globo terráqueo, hagan clic y escojan español. Throughout the program, we'll also be accepting questions, so please, via the question and answer chat box, ask away as we go on. And with that, let's begin. Good afternoon, welcome. I will keep my welcoming remarks very short because the expertise and insight of this next panel deserves all the time in the world. But I wanted to introduce you to your host and my colleague, Ahilan and Arulanantham. The impact both Ahilan and Hiroshi have had on immigration law and immigrants in this country is immeasurable. And personally, I'm so thankful to be able to work for them and for their leadership and mentorship. Ahilan, your next host and one of CILP's faculty co-directors, has successfully litigated a number of cases we're all aware of involving immigrants' rights, including Franco Gonzalez v. Holder, the first case to establish a federal right to appointed counsel for any group of immigrants, Jennings v. Rodriguez, which secured that due process rights of immigrants jailed for years while litigating their deportation cases, and most recently, Ramos v. Nielsen, a challenge to the Trump administration's plan to end the TPS program for immigrants who've lived here for decades. He's argued twice before the Supreme Court and will argue again this fall on behalf of Americans of the Muslim faith who were targeted by the federal government for surveillance because of their religion and FBI v. Fazaga. Ahilan, it's an honor to work with you, and it's an honor to build this center with you. Thank you for all you've done. And with that, I'll send it over to you.
Thank you, Gabriela, so much for that very kind introduction. I'm very excited for this last panel in our fall conference. Let me do a little bit of context setting before I introduce our panelists. So the first year of the Biden administration, has already been a lot. And one of the really striking things about it is, I feel like the executive branch's power to set immigration enforcement policy and to administer even DACA itself, let alone other large-scale administrative relief programs modeled on DACA, has really been cast into serious doubt by the courts. The Biden administration has stated now that it will resume the MPP program after a federal court found the memo terminating that program unlawful. A different federal court declared DACA itself illegal, which was not a total surprise, as the Supreme Court had at least suggested that it might find DACA unlawful at some point in the future. But also not just DACA, but any executive branch program that provides relief from deportation coupled with work authorization. And then even programs that just provide relief from deportation have been enjoined by some lower courts. First, the 100-day moratorium on all deportations, and later, the first version of the prosecutorial discretion guidelines under this administration, though that injunction was then stayed and I'm suspecting now is moot. So against that backdrop, we want to explore two important questions, both with respect to the present moment, but also with respect to the longer term. First, what should the Biden administration do? What should the president do in light of this environment on this set of subjects? And then second, what is the longer term future of immigration law and policy in this area when it comes to these large scale administrative and other executive enforcement programs? To discuss those questions, we are privileged to bring you three of the leading academic scholars on executive authority in the immigration context. They all have extraordinary biographies, which I will not attempt to summarize beyond a few lines. I would encourage you to read them on our conference page. First, we're very lucky to have Jennifer Chacón. She's professor of law at the University of California, Berkeley School of Law. She was previously professor of law at the UCLA School of Law. I will admit I'm still a little sad about that. She has published extensively and has a forthcoming book on the impact of shifting immigration policies on immigrant communities and organizations in Southern California. She also advised President Obama's immigration transition team back in 2008-09 And perhaps most importantly, from my perspective, she was my first student mentor when I took the immigration clinic in my first year in law school, because she was just a year ahead of me. Second, we also have with us Adam Cox. He's the Robert A. Kindler Professor of Law at NYU and a leading expert on immigration law and also voting rights and constitutional law. He too has published extensively. Most important for present purposes, he just co-authored The President and Immigration Law, an extremely important book that explains how the president became our immigration policymaker in chief. And it also assesses the implications of the president's power for the future of American immigration policy. Could not have a more timely book contribution for purposes of this conversation. I will add that Adam and I worked together for 2 consecutive years. We clerked together and then started out at the ACLU in New York together. And ever since, he has provided me superb advice on more of my cases than I can remember. Very happy to have Adam with us. And finally, we have Shoba Sivaprasad Wadhia. She's Associate Dean for Diversity, Equity, and Inclusion, and the Samuel Weiss Faculty Scholar and Clinical Professor of Law at Penn State Law in University Park. Her research focuses on the role of prosecutorial discretion in immigration law and the intersections of race, national security, and immigration. She too has published extensively, both in law journals and the popular press. She wrote a superb book on prosecutorial discretion in the immigration cases in 2015. Before she joined the Academy, Professor Wadhia did immigration policy work as Deputy Director for Legal Affairs at the National Immigration Forum in Washington. So thank you all so much for joining us and welcome to the panel. So let me start with Shoba. You are, in the view of many people, including myself, probably the country's foremost authority on prosecutorial discretion in the immigration context. Secretary Mayorkas just released a prosecutorial discretion memo. A lot of people did a lot of advocacy in advance of this memo, had extensive meetings and discussions with the government about them. Some people were extremely disappointed. And they viewed it as doing almost nothing insofar as it creates so few bright line rules, including none with respect to people deserving of protection. It doesn't say, we should not deport people who are blank, anything, lived here really long, have close family ties, or by any definition. Others have said that actually the memo is quite revolutionary because it seems to require individualized assessments at the point of apprehension. That is, the decision even just to begin focusing on somebody for purposes of arrest, let alone deportation. And they've argued if you actually followed that rule, you would have to end practices that have actually been responsible for huge numbers of deportations. Detainers based on database checks, what they call collateral arrests, when ICE agents come into a house, don't find the person they're looking for, but just arrest lots of other people, and other similarly harsh enforcement methods. I know you wrote a letter with actually Jen and Hiroshi from the center specifically to the administration about the memo, and I'm sure you've analyzed it very carefully. What do you think about it?
Thank you, and I want to thank you, Ahilan, and the center for inviting me to be part of this conversation. I'm really honored to be here. I fall somewhere in between. I think there's a lot of good content in this memo. From my work looking at the history of prosecutorial discretion, it's hard for me to call its entirety revolutionary because a lot of what we've seen, we've also seen historically in guidance documents that guide discretion. But let me talk a little bit about the good and maybe share some of my criticisms. First, and the fact that this is a guidance that is department-wide is important, that it's on Department of Homeland Security letterhead, that it applies to all of the agencies. It allows for the potential for greater consistency and uniformity in the way in which discretion is applied on the ground. Of course, the proof is going to be in the pudding of how boots on the ground actually carry out the guidelines that are in this memo. The memo also does a good job of identifying prosecutorial discretion as a principle, not just as a technical matter or as a sort of Title section matter, but more on a humanitarian way, right? To say that somebody who's undocumented, that alone should not be a basis for an enforcement action. And look, we have people who are working on the front lines, who are helping to protect and save those who are patients with COVID-19. These may not be the most groundbreaking things we might hear or see, but it is quite important to humanize prosecutorial discretion, because it is humanitarian principles that have long guided how discretion is used. Another piece that I would identify are just the mitigating factors that we see in the memo. Even though we don't have what are, in quotes, bright line rules, we actually do have equities that are listed in the memo that have long guided discretion that are in name. For example, those who have advanced or tender age, or long-term residence in the United States, or military service. The fact that these factors should go into the calculus about whether someone should be protected and placed on the back burner are important, I think. Another section of the memo talks about the protection of civil rights and civil liberties. There's one part about it that's actually consistent with what we've seen previously, and one part that's new, and one that I want to underscore. So the one that is historic is just, and also consistent with Supreme Court jurisprudence, is that impermissible factors like race, sex, gender cannot be used when making an enforcement action. We also saw this in the 2000 Doris Meisner memo from November 2000, and we see that imported here, which for all kinds of reasons, including the landscape we're in, is really important to impress upon. But for any, including yourself, who has litigated discriminatory intent or selective prosecution claims, the bar is very high to prove someone's discriminatory intent. So one piece that I find quite important in this memo is that this line, quote, "We must ensure that enforcement actions are not discriminatory and do not lead to inequitable outcomes." Now, we might all agree with that statement as a moral matter, but as a legal matter, the memo didn't need to go that far. And the fact that the secretary cares about what the impact of enforcement looks like shows that he's not just resting his principles on the constitutional minimum. Another thing that this memo does is to, and I'll finish up in a minute then, is to talk about data collection, which again may seem like throwaway or drier language, but the fact that the agency wants to collect data and make it available to the public to the best extent possible is actually quite revolutionary if you think about the record and history of the department's record keeping around discretionary decisions and its historical lack of transparency. So I have some criticisms, but I did want to highlight some of the positives here and look forward to the conversation.
Yeah, no, thank you, Shoba. And sorry to interrupt. The only reason what made me think of it was this concept that inequitable outcomes, right, might be something that the agency has to take steps to stop. Makes me think about two different state or local law enforcement agencies. One which has a pattern of engaging in discriminatory, selective, whether prosecution or arrest or bail practices, or it could be anywhere along the line. And it might be an agency that's even being sued by the federal government or being investigated by the federal government for having those practices. Then you might have another agency somewhere else which doesn't do that. And so the outcomes for the similarly situated person living in those two jurisdictions might be different. It sort of recalls to mind activists asking for the Obama administration to stop enforcement in Arizona after the Arizona SB 1070 statute was enacted, for example. So Jen, if I can bring you into the conversation here, I know you wrote a letter that I mentioned earlier to the DHS about the prosecutorial discretion memo before it was announced. And one of the things that I know you had argued in the letter was that the agency should actually consider race discrimination and efforts to ameliorate it as an argument in favor of more broad and aggressive prosecutorial discretion. And as I recall, you grounded the idea in the take care clause, which is kind of interesting because a lot of times, the suits against prosecutorial discretion and administrative relief programs have actually argued based on the take care clause. Can you explain the idea that you had for this letter, and if you think it's an approach that the Biden administration actually could adopt in light of what the memo already says?
Sure. Sure. Well, first I wanted to first acknowledge my debt. The land that I live and work on is of continued importance to the Muwekma Ohlone people and the other descendants of the Verona Band. So I feel a particular obligation to mention that that fact. It feels really weighty when I'm called to speak as an expert about laws that are fundamentally about unjustly gatekeeping access to this land. So I think it's important to acknowledge that. I also want to thank you most sincerely for inviting me to be on this panel and to participate in the work that your center is doing. It's really exciting what's going on there. I miss you all a lot, and I'm really, really just grateful to be here. And as I told you earlier, I'm going to add this information about being your mentor to my bio, because it may actually just be my crowning achievement. So now I can rest easy. I also, before I directly answer your question, just want to acknowledge that these arcane legal discussions can sometimes make it feel like debates over the kind of right of people to exist or their fundamental humanity. And I just think it's really important that we ground all of this in our sort of realization and acknowledgement that we all share, that real people's lives are affected and real people are really struggling as a consequence of the choices and decisions that are being made every day in this context. And so none of this is arcane legal debate, I think, for any of us. Speaking directly to your question about the take care clause, I think the notion that the take care clause warrants and perhaps requires some kind of formalized prosecutorial discretion isn't a new idea. It's not new to sort of the letter that we wrote. I think you can certainly see it in some of the earlier letters that Hiroshi and Shoba, for example, spearheaded around deferred action for childhood arrivals, right? The argument there is you have millions of people who are potentially removable under the broad sweeping statute that Congress has enacted, but congressional appropriations can't possibly signal that Congress intends for everybody to be removed, right? They've signaled that they only want a certain amount of enforcement, and the executive branch really has to decide then how to allocate those resources. And when they fail to do that well, this actually undermines Congress's enforcement scheme, and it undermines sort of popular will in terms of what immigration law should look like on the ground. And we can see this playing out empirically when we look at what happened under Trump, where there was a sort of elimination of all form of enforcement discretion. And it was just sort of a free-for-all, whoever you could get should be brought into the net. And you saw, more and more people being pushed into a removal pipeline that could not sustain that push, right? So you have lots of longtime residents being forced into a system where there are not sufficient judges, where people are being detained for inordinate amounts of time, where people are waiting decades to get decisions on their cases. That is not a sustainable way to execute the scheme that Congress orchestrated. And so it seems like somebody should be taking care that the law be faithfully executed, and prosecutorial discretion, I think, is a part of that. But I think we sort of wanted to sort of ground this and the further notion that it's not just about sort of appropriate enforcement of the immigration law, but that the executive branch also has other obligations to enforce the law. And that includes giving effect to and adhering to the Constitution's promise of equal protection to ensure that people in the US don't face discrimination on the basis of, among other things, race. And a system where line agents are making unregulated decisions against whom to enforce, or where state and local law enforcement agents are using race in profiling to target individuals who they want to funnel into the immigration enforcement system, results in invidious discrimination. Invidious discrimination on the basis of race becomes de facto policy. So to avoid that from happening, to enforce the equal protection guarantees of the Constitution, the executive branch needs to actively guide the use of enforcement discretion. Relatedly, we know that the criminal legal system disproportionately targets and criminalizes Blacks and Latinos, which means that if you just go ahead and blanket use criminal convictions as the basis for your prioritizing for removals, you're going to disproportionately and unfairly target Black and Latino immigrant residents. So to avoid this, immigration enforcement agencies and officials need to make nuanced assessments that Shoba was talking about, those sort of holistic look at who the person is, that take into account both individual equities and the realities of systemic racism. So I agree with Shoba, the enforcement priority memo that the DHS issued last month is important, right? And signals really strands for hope, right? It takes that very important step of prohibiting the use of the invidious use of race, ethnicity, national origin, religion, gender identity, sexual orientation in enforcement. So that's really significant and important. It also expresses the same expectations for state and local and other federal agencies who are partners in immigration enforcement. That's really important if meat can be put on those bones. It remains to be seen, as Shoba said, how meat gets put on those bones, right? So there's a question mark there. So the signal is important, but a lot will, kind of the proof will be, as Shoba said herself, in the pudding. And I think the other thing to just acknowledge is that any system of immigration enforcement based on the laws that we have and the global order that we have are going to inherently reify racial hierarchies and perpetrate racist systems. So there is a limit to what one prosecutorial enforcement discretion memo can do to address systemic racism in immigration enforcement. And so that's the huge caveat on the back end of what the memo can do and does do.
Thank you for that. Adam, let me bring you in. Jen was saying, in particular, sort of dragnet programs are more likely to perpetuate race discrimination that's sort of underlying in the criminal legal system, right? Because if you just sort of blanket, taking people from that system and bringing them into the immigration system, and you don't have a sort of separate filter, then you're necessarily going to replicate it. I think you're the one who first gave me this idea that the memo might actually require individualized assessments, because it doesn't permit people to have database to be subject to arrest based on databases, and that it might have a problem. I mean, if you think about ICE officers coming into a house and looking around and deciding to just arrest anyone, they're going to more likely to arrest people who look like immigrants, right? Than which is obviously going to be in part based on the color of their skin. I mean, do you think that's sort of a plausible reading of the memo, and do you think that's something that the agency could implement, or that the Biden administration could implement?
I mean, I do think it's a plausible reading of the memo. I think it highlights the way in which, as Shoba, I think, suggested, the memo is kind of a double-edged sword. If you put Shoba's comments with Jennifer's comments together, you can see, well, one way to try to reduce racism in the system is to centralize decisions. And obviously that was in part a motivation of the centralization that we saw during the Obama administration. And so if you tell ICE enforcement agents in a prosecutorial discretion memo, you must make an individualized enforcement decision prior to apprehending a person. So in one sense, that's a decentralization. So it runs up against this idea that we might like centralization in order to eradicate impermissible decision-making by line-level agents. But on the other hand, if you have a system that, as Jen says, is already structured to sweep in people and to have a disparate impact, at least on the basis of race, irrespective of the motivations of those line-level agents, then putting dampers on the front end of the system can also reduce the likelihood that it leads to those results. And so I think it highlights the way in which administrations have to walk a fine line. Another example is secure communities, which massively centralized enforcement. So it created an opportunity to reduce enforcement against folks who didn't have criminal convictions, for example, and police enforcement decisions for profiling. That was supposed to be part of what the program entailed in its integration with the Office of Civil Rights and Civil Liberties within Homeland Security. But on the other hand, we know from empirical work that secure communities, what predicted which communities were activated first under this massive enforcement program, the percentage of the county's population that was Hispanic, that was the single best predictor. Not crime rates, even though it was supposed to be a crime prevention program, nothing other than the demographic composition of local communities.
I'm remembering now your studies on this, actually, right, on secure communities activation in different parts of the country. We'll leave the memo, although I'm glad we started with it because I feel like the interior enforcement discussion is so important and understandably gets sort of drowned out in the discussion about the legislative process and the border and all these other things. But let's turn a little bit then to the sort of administrative relief part of the equation. Adam, let me stick with you for a minute if it's okay. Your recent book with Professor Rodriguez, it begins with a detailed study of the history of presidential power over immigration policy, and it starts with parole, the parole authority, which is sort of this instrument of foreign policy, but also this mechanism of bringing people, thousands and actually hundreds of thousands of people, right, historically into the United States. Thousands of Afghanis just got paroled into the United States, in the drawdown that just happened. Some advocates have championed the idea that the Biden administration should use parole, or what's called parole in place, to protect people who are already here. So it would serve a function something like DACA, but these advocates argue perhaps on stronger legal footing. There's also a legislative proposal now that we heard a lot about this morning, Plan C, which is sort of legislative provision of parole for people, giving them work authorization and protection from deportation for something like five years and another 5 years. There's different ideas floating around. So can you explain for folks who may not be totally familiar with this, what is parole in place? And what are your thoughts on it as a mechanism for large-scale administrative relief, given all the context that I did at the beginning about the courts and all the difficulty of all this stuff?
Sure. To understand parole in place, I think maybe I should say a word first about parole itself, the idea. And parole is basically just a legal term applied to an idea that's very old. Almost as soon as the United States began to exclude non-citizens from the US, immigration officials in Congress recognized that it needed mechanisms to permit authorities to let into the country people who were otherwise inadmissible or excludable. So as early as 1907, there's provisions in the book that allow for this. And then in the middle part of the 20th century, 1952, Congress codified a delegation of power to then the Attorney General, now the Secretary of Homeland Security, to let into the United States, to parole into the US, people who were otherwise excludable. So that's what parole was. It was imagined to be a power that would be used as a kind of interstitial case management device to deal with, a person who arrived at Angel Island or Ellis Island and needed medical care. But presidents very quickly realized that they could use this power to craft refugee policy. And so refugee policy in the second half of the 20th century was basically built on the back of the delegation of parole authority. And then this authority was transformed in the mid-90s when Congress made some changes to the immigration laws that moved the line, the regulatory line, from entry into the country to admission, and said, if you've entered the country without inspection, you still need to seek admission under the law. Well, that technical change, Congress maybe didn't realize at the time, meant that people who were living in the country but had not been inspected and admitted were actually eligible for parole. And in a memo from the General Counsel's Office of the INS in the late 90s, the INS recognized this fact and initiated the idea, in a way, of what's now known as parole in place. And so, as you said, a lot of advocates have suggested that maybe parole in place is a better vehicle than deferred action programs like DACA to protect non-citizens from deportation. That idea isn't new to the Biden administration. Secretary Mayorkas, when he was the CIS director back at the beginning of the Obama administration, was involved in efforts to consider different options for relief, and in internal memos, parole in place was an option on the table back then. So it's an idea at least a decade old. But it's gotten new currency, I think, because courts, as you noted in your introduction, have suggested that they might strike DACA down. And so one thought folks have is that maybe parole in place can succeed legally where DACA doesn't. The reason is this: a principal challenge to deferred action programs has been that Congress has not expressly delegated a deferred action power to the Department of Homeland Security or other executive branch officials. And that's part of what has led to claims in the litigation against DAPA and DACA that the president's exercise of deferred action authority is somehow a usurpation of Congress's powers. That's not an argument that can be made about parole because Congress wrote into the statute a delegation of this authority to executive branch officials. So in that sense, it's on firm legal footing. The other thing that's attractive about parole is that once people are paroled, they can actually adjust their status in many cases to become lawful permanent residents. So while programs like DACA and DAPA provide immediate relief, but leave people in a kind of limbo because there's no path forward for many folks to permanent residency and ultimately citizenship, parole, for some folks at least, can put them on a path to green cards and ultimately to citizenship. So I think that's part of the legal and political appeal, but there are disadvantages. One disadvantage is that parole in place is available only to people, as I said, who are seeking admission, which is a kind of term of art. And what that means is people who entered without inspection can receive parole in place, but people who entered the country lawfully, were inspected and admitted, but later overstayed their visas, are not eligible as a general matter for parole in place. And so that would mean that a fair number of people, for example, who were able to receive relief under DACA would not have been eligible for a parole in place program that was designed to try to capture the same group of folks. It's also true that parole in place has different trigger conditions, right? Technically, the statute says it should be used for urgent humanitarian reasons or for significant public benefit. And while courts historically have not reviewed the executive branch's decisions to grant parole and has really deferred to political choices about when parole was appropriate, in this current climate where it seems like courts, or at least some courts, are more skeptical about the executive branch making large-scale immigration policies, you can imagine a court using that statutory language not to empower executive branch policymaking, but instead to hobble it.
Thanks. And I know I've seen some estimates that suggest, probably nobody knows, but that it might be 30, maybe even more, 40% of the population of quote unquote undocumented people who came here on visas and overstayed them. And if I understood what you said correctly, at least many people think that if you came on a visa and then overstayed it, then you're not eligible for parole. Let me just throw another administrative relief sort of concept out there, and Jen, if I'll throw this one back to you. Another idea that advocates have talked about a lot is large-scale TPS expansion. Actually, this morning's panel, you heard several people, Pablo Alvarado from Endelon, and also Geraldine Joseph, and I think Karen may have said this as well, Karen Tumlin, say, what is stopping the Biden administration from just granting TPS to a number of, redesignating, so sort of updating the date to protect, and then perhaps also adding Guatemala, I think is something that Karen Tumlin had mentioned in particular, and the effect of this would be potentially very large if you had a lot of people from countries granted TPS. What do you think about that as an administrative relief alternative? Sort of what are the upsides and downsides of it from your point of view?
Thanks. So I think Adam identified one of the downsides in his earlier remarks, which is that, in and of itself, TPS is sort of a path to nowhere, right? It's a perpetually temporary state. Karen Tumlin on today's earlier conversation just noted that this is really requiring people to sort of live their lives in 18-month increments, right? Will my TPS status be renewed, et cetera? DACA is similar in that way, right? So these are people who wind up being in this sort of extremely liminal status where there's always the question mark about what the future holds. It makes it really difficult to make life decisions and plan, and people are sort of stuck with that constant limbo state. So I think that's the disadvantage of TPS and of many of the kind of forms of executive relief that we're talking about, though not all. And so that's just one thing that should always sort of keep us focused on the need for Congress to do something that's more permanent and that actually offers kind of stable, meaningful relief for people. But that said, kind of acknowledging the shortcomings of TPS, about which many people have written, including some of your colleagues in other departments at UCLA, like Cecilia Menivar. We, you know, I think the panelists this morning were very clear, you know, something is better than nothing. And there are lots of people who are in worse than a limbo state, in the sense that they're sort of trapped outside of the law. And this would be a way that the president has the power to wield, right, to bring people sort of under the umbrella of the law. So here's another place where Congress has designated, or has given the president this power to designate people recipients of temporary protection when certain criteria are met. And as the earlier panelists noted, Guatemala is a pretty clear case for this, right? There are lots of ways in which ongoing disasters, many of which have sort of underlying climate causes, perhaps, but sort of manifest in terms of scarcity and war and violence, have kind of fit the criteria for TPS, right? So that's a plausible solution. There's even talk about, you know, could you give TPS to Mexicans given COVID, right? The sort of reality of COVID is a temporary displacing force that makes it dangerous to return. There are ironies, of course, to that sort of framing of TPS. If we think about COVID in the United States right now, the fact that numbers aren't good, the fact that many of these workers who would be drawn into this umbrella are actually workers who in the United States are positioned as frontline workers most exposed to the dangers of COVID and least likely to be able to get healthcare in response to COVID, right? So there's an irony to that positioning, but there's pretty much always an irony to US relief programs. The same is true for asylum, right? With people seeking asylum for the kinds of discrimination or abuses that sometimes seem to manifest in the United States or as a result of US policy. So I don't think irony is a reason for the administration not to take seriously the notion that it has this capacity to expand. I think the sort of final drawback, or one of the reasons that the administration might be slow to act, is this, you know, kind of fear of political consequences, right? That it will, if it looks like it's being overused, it will be litigated, right? We saw litigation on the other side when Donald Trump tried to rescind TPS status, so we can assume that there would be litigation flowing the other way, and that could imperil TPS in some form or fashion. And so there's really the weighing that needs to happen about, you know, are you going to not do something out of fear of litigation and potential consequences, even when the costs are that it means that there's a large number of people living in a limbo state who could really fit comfortably within the confines of what the statute says. So I think my impulse would be go for it, but I want to sort of acknowledge that there are real political choices that are being made when that decision is undertaken.
The interesting thing you say about coronavirus and the irony and TPS for Mexico, in a way, it's almost like the mirror of the Title 42 policy in a sense, right? Because the Title 42
Yes.
argument at some level is like, look, anything you do to move people into a building for even a short period of time creates a risk of coronavirus. And so, you know, sorry, we have to essentially abrogate the Refugee Convention because, and the CAT as well, I suppose, you know, the Convention Against Torture because of this. And in a way, it's almost like the mirror image. Like, look, maybe we have lots of COVID here too, but it's dangerous to send people, just like it's dangerous to bring people. And so, you know, we don't want to increase that by actually trying to send all these people, you know, repatriate all these nationals. It's interesting. It's a really interesting idea. You know, let me throw one other one. Actually, sorry, one thing I should mention, Cecilia Menivar is the professor you mentioned at UCLA, right, who's done a lot of really interesting work on temporary protected status, in case that wasn't clear in the recording. Shoba, let me ask you, I want to put one other kind of idea for a large program on the table in the present moment, and then, you know, then maybe we can move the discussion a little bit to the future. Another thing that was said in the morning discussion was the idea that the president might grant deferred action, not work authorization, but just deferred action to the people who would have been protected under the Day 1 bill, which feels like 7 years ago or something. But in the first 3 weeks of the Biden administration, there was a massive legalization bill that was put on the table, and this, in a sense, was the normative statement of the administration, their view about the people who they believe are deserving of protection. So it's an interesting idea. Could the administration say, if you meet this set of criteria, we're not going to target you for deportation? What do you think about that?
Well, I don't even know that that's a terribly new idea, right? The idea that people who have been living in the United States for long periods of time and are living without status because of congressional inaction may be the very same people who bear the equities and qualities that are ones that should be protected through a type of prosecutorial discretion like deferred action. So I think there's a consistency between who the administration is prioritizing, who it's leaving on the back burner, and the idea of using discretion. Again, it's going to go to what are the political consequences and what is the will that the administration might have. But deferred action's been around for decades, and it has been used on a case-by-case basis for people who have the same qualities that are part of the day one immigration bill. And for those who may benefit, we do have a regulation that's been around since 1981 that allows for somebody to apply for work authorization after being granted deferred action. That's been around long before we had a DACA. So I would also argue that those who've been granted deferred action under sort of the day one bill class would also have a basis for work authorization.
Thank you. I want to switch to sort of divisioning, but before we do that, is there anything that anyone else wants to say about present moment topics or anything we discussed thus far?
I wanted to say a few things in response to Adam and Jennifer, because it got me thinking about things. So I think parole is just, and I wish I had a slide. There are a lot of different flavors of parole, right? Parole in place is one type of parole. But it's a great example of how every agency that handles immigration in the Department of Homeland Security has the authority to grant parole. So for ICE, that would include releasing someone on parole. For CBP at the border, that would include perhaps doing a port parole for an Afghan or someone else arriving at the border without documents. And for USCIS, it could include processing parole in place or humanitarian parole, which is another type of parole that many Afghans are seeking. So it sort of confirms the idea that all three agencies have the authority to exercise prosecutorial discretion. And that is what parole is. Parole is a type of discretion, or it is a mechanism for a lawful entry. It is not the same thing as legal status. The piece I wanted to respond to on TPS is that it really gets us to, what we're really talking about is capital D discretion, right? The president has discretion and the secretary to do many things, including expanding TPS, including ending Title 42, right? So when we think about discretion and the principles that should inform discretion, those are principles that should be consistent whether we're looking at the prosecutorial discretion memo from September 30th, but also when we're looking at the discretionary choices the administration is making at the macro level.
And that seems a very good segue for us. In particular, I mean, when you say the prosecutorial discretion, the regulation providing employment authorization for people who have deferred action has been around since 1981. But then you have the Supreme Court decision, which arguably suggests, and a district court decision that essentially holds oh, we don't care. that doesn't mean that you can run the DACA program, right? You still can't couple these two together, even as you say, people have done it for decades, right? Or the government has done it for decades. And I guess that sort of that's why I think of it as a segue into a second part of our discussion here. these big administrative relief programs, Adam, you say there was like hundreds of thousands of people who come, and obviously DACA is even larger than that, 650,000 people. The TPS population now is more than that, actually. If you add something like 300 something thousand Venezuelans, it's perhaps nearing 1 million. But we've seen so much skepticism. Like, are we done? Well, let me give you a couple different menu options, and I want you you all to tell me, right? Like, are these huge programs, DACA being the sort of flagship example in recent time, are they done, period, given the court's skepticism toward them? And also what feels like, even outside of immigration law, an attack on the concept of massive executive power and administrative discretion in the administrative state more generally, that we're seeing from this sort of movement in the judiciary. Sort of B, that's sort of one option. Another option, are they done if Democrats do them, or if they're but not if Republicans do them, given the way the courts have gone? And my sort of big exhibit for this would be Venezuelan DED, done late in the Trump administration. 320,000 people granted the status under the DED program, which is, you all would know better than me, but it's another one of these sort of big, sort of generic, the president can do whatever they want kind of powers, but not a peep, no lawsuit, no criticism, and all that happens is President Biden comes in and quickly gives TPS to all the people who just already had DED. So is that sort of the way we're going, where it's going to become like hyper partisan? The courts will allow a lot of executive power for Republican presidents, but not very much for Democratic presidents. Or a sort of slightly, I think, a different version of that might be, these programs are done if they're trying to liberalize the immigration law, or liberalize in the sense like let people stay here, give people work authorization, exempt certain people from deportation. Whereas if we're talking about executive power to restrict, like the Muslim ban or the Africa ban, or other Trump era programs that actually restricted control, then the courts are going to allow that, but they're not going to allow ones that are liberalizing. So those, maybe you have other options, but anyone jump in. What are your thoughts on this more generally in the future, like longer term from just this present moment? Well, I get to call on the professors. Adam, why don't you go first?
Okay, so I guess let me say something about the premise of the question, maybe, and then I don't have a great answer, but a thought. So the premise suggests that maybe we could have a world that doesn't involve massive immigration policymaking in the executive branch, and I think that's actually not a possible world right now. So I think it's inevitable in a world where nearly half of the non-citizens in the US are here in violation of law, and Congress isn't doing anything, that the executive branch is in one way or another going to make a bunch of really important decisions about what immigration policy looks like. So it seems inevitable. And I think politically, it means that presidents have really powerful incentives to control these policies, so long as immigration remains among one of the most important issues to voters, right? And generally, across both Republican and Democratic administration, control means centralization. Like, not in every instance it's true, because, for President Trump, there was less conflict with the line level officials, and so delegating that more discretion actually was a way of controlling the issue, getting the policy outcome that he wanted. But in a lot of areas, and even for the Trump administration, control typically meant centralization. So there's, so it's inevitable. There's a political will on the part of presidents to control these policies. So the question really is, what are courts going to let them do going forward? I don't have an answer to that, but I will say, I do think there are cross-cutting ideas about presidential power that the courts at some point are going to have to confront, because on the one hand, you see some lower courts and the Supreme Court indicating that they're concerned about centralized control over enforcement discretion. This is really about fights between the center and the line level. And if courts shut down programs like DACA or large-scale parole in place, it will be by rejecting the idea that you can control those in a centralized fashion. But while courts are indicating skepticism about that, at the same time, they're reinforcing the idea that there is and should be centralized control over lots of other actors. So the court repeatedly affirms the power of the Attorney General to control the immigration courts, to dictate exactly how they'll decide asylum cases. And the theories that are justifying control in those instances are exactly the theories that the court's rejecting in the other cases. And so at some point, it seems like this is going to come to a head, and how the court resolves that tension might tell us like whether we end up with a power that's largely symmetrical, can be used by both Democratic and Republican administrations, or whether we end up with a conception of presidential power that is gerrymandered in a way that makes it partisan for purposes of immigration policy.
I love your use of the concept of a voting rights concept here, thinking about gerrymandering presidential power. What do Jen and Shoba think about this question?
I mean, I'm not ready to say we're done. And for the same, and I'll pick up with something Adam said about inevitability. Prosecutorial discretion is inevitable, right? And what is distinct is how it is exercised. So it's not just a talking point that we have 11 million people living in this country without papers, and we haven't seen action on immigration in more than 3 decades. That's going to cause a situation where choices have to be made. They can be made haphazardly or as an open season on immigration, as we saw in the last administration, or they can be more focused, as we are seeing attempted in this administration, and certainly in prior administrations too. I am not qualified to judge how the courts are going to act, but I do think the window is still too small to make predictions about whether the future of prosecutorial discretion policy is partisan, right? I don't think we have a history to say that, and I think we have too short of a window and are still recovering to make predictions about the future in the long term.
Go ahead,
I think, I think to that I would just add that I guess I'm slightly more pessimistic than Shoba in the sense that I think I'm willing to sort of lay some money on the idea that we will see. We're calling it a partisan sort of kind of approach to sort of how much power the executive has to call these shots. But I want to push on that just a little bit, because I think Democrats and Democratic presidents have not been particularly, they haven't always been particularly full-throated, and we're certainly seeing that with this administration, in defending their attempts to enact large-scale reform. And they have been just as full-throated, I think, as have Republican presidents in some senses, in defending their prerogative to keep immigrants out, right? And we're seeing that with the Title 42 litigation, among other things, right? So I think in part, I'm not ready to call it yet, right? But in part, I also feel a little bit of pessimism about this, because I think there is a sort of a shared commitment that sort of crosses the partisan line to maximizing presidential power to exclude immigrants. That's not I think we see it certainly more maximalist sort of under Trump than under Obama or Biden, but we also don't see sort of the clear opposition of Trump versus Obama and Biden that might let us sort of test out what that looks like. And I think this goes back to Adam's point about sort of the kind of, this is a hot button political issue, and that's true. We know that. We also know that it is much more of a hot button political issue for Republicans than for Democrats overall, right? So it's a much more higher valence issue for Republicans. It's an issue they focus on and care about, and their presidents, therefore, also focus and care about that issue in particular ways. Whereas for the Democratic Party, it's kind of down the chain on the list of issues that motivate and activate, right? Which is why I think the panelists in the the last session are so amazingly frustrated and tired, right? Because the kind of work it takes to sort of get Democrats to focus and mobilize on these issues is tremendous. And so you see the fatigue around that as well. So I guess I think we, as we're sort of thinking about how this plays out in the courts, we also need to think about courts as being responsive to the political pressures on the ground. And there are differential ways in which those political pressures are being mobilized in this space.
It's such a good point that you make about the appetite for pushing on it, for pushing to enforce your priorities in the face of court opposition. One thing that one of the morning panelists had mentioned was that the Muslim ban was struck down. It's actually struck down twice. You could imagine, if the Muslim ban is the moratorium, right? Imagine a world where it gets struck down and they're like, fine. And then like life goes on and you tell a very different story. This conversation is completely different, obviously, in that world. And the course of history would be so different if the Muslim ban had been struck down in a week or something and had never gone into effect after that. Let me ask you another thing about this, Jen. In our discussion preparing for this, we had talked a little bit about Venezuelan DED, and you had a particular account which I thought was really interesting about what's going on here. This idea that 300,000, 20,000 people are given this form of protection. And I should say, I've heard some of my clients, TPS holders, talk about this and say, they're incredibly happy and grateful and sort of feel so much thankfulness that TPS holders, that people from Venezuela were given that protection. 300,000 refugees who had come to this country were given that protection, but they're still struck by the inequity of it nonetheless, right? I'm thinking about a Salvadoran woman, Cristina Morales, who's a very outspoken leader in the TPS alliance and is my client. And you had a sort of a theory about this, what is going on here, that these 300,000 people come here. There's no discussion of the magnet effect and the concerns about it'll signal the open border. There's no, nothing, like I mentioned earlier, none of the sort of resistance that you see to so many other initiatives have come. Do you want to say a little bit about that?
Yeah, I think we were trying to puzzle through how did that happen without a glitch? And part of it is, I think, that Democrats had little reason to oppose what seemed like the right humanitarian policy, and if Republicans were behind it, great. So there's that that's the narrow window, but I think it also fits into the trajectory of who gets humanitarian relief in the United States and who doesn't. If we sort of think about the long haul, there's a story that we tell in the asylum context in particular, that individuals who are fleeing from right-wing authoritarian regimes backed by the United States are seen as not valid asylum seekers. They're sort of taken outside the sphere of protections, and there people who are fleeing left-wing regimes are seen as freedom fighters coming to the embrace of the United States. And we see this in the dichotomy of sort of the first wave of Cubans versus what happens to Haitians. We see this in kind of playing out on the ground in Central America. And so in some ways, the Venezuela story fits that arc, and there is a racial element to that arc as well, right? So the people who are fleeing and opposing right-wing regimes are often poor people of color, right? It's obviously variegated on the ground, but I think there is a story about race that we need to tell when we're sort of thinking about how relief gets mobilized and when it is more likely that relief will be activated, and when regimes will be more sympathetic to asylum seekers and claimants for humanitarian relief. So in that sense, we could see consistencies in the historical narrative. So maybe it's not then surprising that Haitian migrants are still being turned back, under horrifying conditions, and we have 300,000 plus Venezuelans sort of getting in with a wink and a nod, and both parties coalescing around it. So that would be the sort of depressing take. And I think it's obviously more complicated than that, but I do think it's important to sort of think of the role that politics play and how we construct who is worthy of relief, and to think about how that politics overlays with race as well.
Thank you so much. I think we just have a minute left here, so I'm going to ask Shoba and then Adam if you have any concluding thoughts on any of the discussion or anything particularly you want to leave the audience with on the subject about administrative relief, either in the short term or in the long term. Shoba, you want to go first?
Well, sure, and maybe to help with connecting it to some of the questions we didn't get to, discretion it's a powerful sword and it's a double-edged sword, right? And we've been talking about ways in which discretion can be used to, advance our shared humanity, and ways in which that it can undermine it. So if we're really going to think about discretion through a lens of our shared humanity, and Biden's commitment to humane immigration, that should be the principle that guides the future of administrative relief, as well as the existing policies that where the administration has a choice to promote, advance, or dismantle. So that's what I'd like to see moving forward.
Thank you. And Adam, any closing?
I guess the only last thing I'll say, we've covered a lot of remarkable ground, is maybe just to emphasize that while we've talked a lot about courts and what courts will put up with, essentially, like what might be blessed by courts or invalidated, I do think it's important as folks think strategically about which of these options are best. When we go back to your first question, what should the Biden administration do, is to think not just about what courts might accept, but also as a matter of administrative law, like what policies are most likely to stick, right? Because sticking is not just a matter of surviving, a court challenge. A policy like DACA, even if sustained by courts, can be reversed quite quickly by a new administration because it's a discretionary policy involving enforcement. Whereas a notice and comment rulemaking, is more practically entrenched against rapid repeal because a new administration would have to go through that process. And so that's another way in which, these options, TPS has its own renewal process, some of these other things can be done through guidance, but also through notice and comment rulemaking. And I think those kind of procedural aspects need to be considered because, as Jen said, these policies so often leave people stuck in limbo, but that limbo can come in different forms. And it can be, pulled out from under folks very rapidly, or it can come in a form, while not amounting to permanent relief, still provides a little bit more security. And that for some people is a really important difference.
Well, thank you all so much. This is a really, really interesting conversation. Actually, I should say, Jen, because I gave you a question, and then is there anything else that you want to add to the context of this discussion? I know we're a little bit over, but that's okay. Go ahead. I'm sorry.
There was a question in the chat about registry and changing the registry date, which obviously is a legislative solution, right? Moving up that date would allow people to kind of gain a potential path to citizenship, sort of if they've been here for a certain amount of time and that date has just not moved. That's a legislative solution. And I do want to sort of kind of echo Adam's words about sort of where we're looking in a different way. We've been talking about what the president can do, but I think I'm sitting here thinking about the fact that we are, that we are kind of living in the aftermath of the Obama administration's failure to live up to its electoral promise to enact immigration reform in its first year, and trying to think about what the political landscape would look like now, 12 years later, had that promise been lived up to, and what would be different about the political system with the citizens that would be part of the political process 12 years after the enactment of DACA. And I'm sort of horrified looking at some of the legislative proposals that have wait times for DACA recipients to get to citizenship, as if the 12 years wasn't wait time enough. And so I do think that we have sort of failed to fully enact the imaginative possibilities here, and we should really reflect back on what has been lost and make sure that we're not ceding additional unnecessary ground in the moving forward, because this is the baseline today.
So let's go ahead and move to the Q&A. I'm sorry, I think I've mixed up my timing of it here. The question that you're just speaking to a little bit was about registry, right? Let me go ahead and read the question out. I'm sorry, I've made a bit of a hash of this, but the question was, how would a change of date to the registry work? That was an option that was rejected by the parliamentarian, right? So let's shift gears a little bit now, talk about legislative. I mean, you were, I think, speaking to this sort of at a high level, the question of whether we're ceding ground in a sense by having a wait time with respect to this. I mean, I guess the parliamentarian half of it, I don't know if anybody has an interest in speaking to that particular question, which is about whether a 2/3 as opposed to a simple majority in the Senate would be required in order to update a date to the registry. Does anybody want to discuss that question? No particular takers. I mean, I can say, you know, there's a set of very arcane Senate rules about what counts as a bill that changes, has a budgetary impact. And if it has a budgetary impact, then it fits under something called the Byrd rule, which means that it can be done as part of a budget reconciliation bill, which means it can be done with 50 votes or 50 votes plus a tie-breaking vote. And so the sort of central question for all of the immigration proposals that have been put forward to the parliamentarian right now is, are any of these proposals, you know, whether it be essentially just a large-scale legalization program similar to what we saw proposed in 2013, or an update to the registry, which would just sort of essentially allow people to get lawful permanent residence if they have been here prior to a certain date, subject to certain exclusions for criminal grounds or things like that, or this Plan C idea that we talked about this morning. The question for all of these is just, do they have a budgetary impact, and does that budgetary impact outweigh their sort of policy effect or non-budgetary impact? And what we've seen from the parliamentarian rulings thus far, there hasn't been an immigration bill that the parliamentarian has thought would satisfy that and be allowed to be passed by 50 votes. Adam, go ahead.
Well, if I could just connect that to something Jen said a minute ago, because I do think those are also examples that raise the question of how serious the Democratic Party is about reform. Because under the Senate's rules, what the parliamentarian technically does is provides advice to whoever is presiding as chair over the Senate. But ultimately, the senators themselves are the ones who are responsible for making a judgment about whether a particular amendment is out of order with respect to the Byrd rule. And you know, what we've seen so far is no appetite on the part of the Democratic caucus to make an independent judgment about that. And so, you know, you might think this is another example that looks a little bit like, you know, the administration's decision not to appeal the injunctions against the initial moratorium, or, you know, not to push back harder when the courts said Title 42 needs to be, the Title 42 bans need to be reinstated. You know, there are other courses the Senate could take that they're not taking right now.
But I think it's interesting when we think about sort of, is this something that has budgetary impact? And I know there's particular ways that question is framed for the parliamentarian, but it's also interesting to me that this is the basis upon which states like Texas routinely are given standing to argue in courts against administrative immigration policies, right? That it's a budget impact to them, right? That's why they have a stake at the table, and so, or a stake in the game, I guess I should say. I'm mixing metaphors, but I think it's really interesting, sort of when immigration policy is a budget issue and when it's not, and that, you know, that too sort of gestures to the malleability of the question.
Yeah,
and and sticking to that theme, I mean, a lot of prosecutorial discretion is also about money, right? And the resources an agency has. So we could convert this panel, right, into budget, immigration policy, and race, but we won't. But I think there are a lot of entry points for that topic.
Yes, in fact, my understanding is that one of the arguments that was presented in favor of it was exactly what Jen is saying, and you know, there's a lot of statements by Republican politicians opposing legalization programs on the ground that they would cause lots of people to have access to benefits, and therefore would be a drain on the federal government's sort of fiscal resources. But it wasn't good enough. So let's take another one out of the chat. This one touching on the question of legal immigration. Would the panelists agree that the State Department's limiting and disrupting available routes to legal immigration, like through Trump policies like the immigrant visa prioritization, which went into effect in November 2020. I could add the policy, the stoppage of the diversity visa lottery, which is still in litigation, actually, that has not settled despite the change in administration. Would the panelists agree that these work against the administration's priorities generally? And I think it's sort of an important question about thinking about, like, what is the relationship between the massive slowdown in legal immigration that we've seen, since Trump administration generally, since coronavirus even more so, and that's actually continuing in the Biden administration, at least thus far, the relationship between that and all the other stuff we're talking about unauthorized migration and government policy in response to it. Anyone? Jen, you want to start on this? Or sorry, Shoba, go ahead.
Oh, I mean, I don't feel qualified to be the ambassador for this question. But I would, again, if we're going to be guided by principles, right, as well as commitments that were made by the Biden administration about what our immigration policy should look like. And we are perpetuating policies that have some type of prioritization or preference that leads to inequitable outcomes, for example. That could be an example for where we want to scrutinize a policy. A lot of legal immigration too, needs attention by Congress, which is addressed partially in the Day One immigration bill, but with all of the political challenges that we've been talking about.
You're muted.
So Jen or Adam on this question. So then let's move to this again. I think Shoba, you picked up on this a little bit in one of your prior remarks, but now let me put it squarely in front of us. It's a question about the double-edged sword nature of discretion, and particularly the idea: is it possible to constrain discretion, and through the constraint of discretion, to achieve progressive goals? And I feel like in a way it sort of leads back to something, Adam, you had said about how, in theory, centralization could be a mechanism for advancing progressive goals by constraining line officers. So it's like two different centers of discretion, either at the line level or at the center, and can one be used to constrain the other? Do you have any thoughts on this question?
Sure. I mean, I think Congress can clearly constrain discretion. I mean, I think that when we talk about the power of law enforcement agencies, not just in immigration law, but in lots of areas, we think like, what's an ultimate solution? You see movements for decriminalization. That's a way of constraining discretion, right? Sentencing changes that can have the same kinds of effects. So one powerful way is to rewrite substantive immigration law. And if not so many people are formally deportable, then the system looks really different. Absent that, I think it is important to recognize that mostly what we do is we move discretion around. And so the most important question is who wields the discretion. And there's no obvious, a priori reason why, discretion in the hands of the centralized few is always better than discretion in the hands of the lower level many. Like, you can't answer that question in an a priori, fashion without reference to the actual institutions that are operating in the political environment in which they work. But the basic claim of the book that Christine Rodriguez and I wrote was to say, if you look at the long history of immigration law in America, in general, we do better when we put that discretion in the hands of officials who are politically accountable. And politics becomes the vehicle to constrain discretion because voters at least have someone to whom they can hold account. And that doesn't mean you can't end up with a President Trump who uses that discretion and wields it in ways that are deplorable. But we think, in this kind of second best world, political accountability is the best we can really hope for.
Yeah, if you sort of leave immigration entirely aside, and think about what civil rights advocates have said for such a long period of time in a variety of contexts, but particularly in the criminal context, people have often said, we want less discretion that you'd rather, both sort of in a general matter, even if you leave the racist sort of history of the country aside, you'd rather live in a system where there were super clear rules and they were enforced equally across everyone, and people could know very well what was sort of lawful and not lawful. And obviously, when you add on top of that the history of how much discretion has been used to create discriminatory enforcement, in an ideal world, that's the system you would want. And the oddity of the immigration law is that you find immigrants' rights advocates always arguing in favor of more discretion, given the substantive law that we have. Go ahead, Jen.
I think also it's worth focusing on in the question, the language line DHS officers, and so Adam sort of made the point, kind of about sort of what you kind of taking all things as equal, right? It seems like you'd rather centralize. And I think in the context of DHS line officers, we can't take all things as equal given the sort of history, the origins and histories of these enforcement agencies, right? So we sort of know what their mission has been about from the kind of constitution of the INS and even before, and certainly on through the arc of DHS. And so that mission has sort of been interwoven with sort of a kind of prerogative to exclude particular people and particularly people of color. And so that's sort of woven into the DNA of these agencies, right? And so whenever you're thinking, and I think we can kind of draw the analogy to the context of policing as well, right? When we think about sort of the way that people are debating the role of the police and discretion by police officers, right? We have those same histories when it comes to law enforcement. And so, I think part of the push toward centralization is sort of a sense that perhaps politically elected leaders elected in new era can sort of move agencies and individuals who might otherwise be inclined to use old systems and methods in a different direction. Ultimately, I don't know how optimistic I am about that. I think I probably side more with the sort of abolitionist approach on this, which is you just need less of the enforcement and less of the agencies, right? And that's the only way that you sort of ultimately move away from the problems. But I do think that it is in part in response to sort of how these agencies originated and how they're constituted currently that we see this push to move discretion up.
Now, unfortunately, sorry, go ahead, Shoba.
Oh, I just, I'll add sort of less remarkable points. And that includes, culture and just buy-in from a bureaucracy, right? And those things have to exist. If you want line officers on the ground, really what this question is about is how do you ensure that Department of Homeland Security guidelines on discretion are actually followed, right? On the ground. That would be a different way to reframe the question, to avoid abuse of discretion. If we were in an employer and an employee relationship at a company, right, I'd be fired for not following guidelines that were being directed from the CEO or company head. What is it that makes it different in an immigration enforcement bureaucracy? Partially, it comes from some of the history that Jennifer talked about, but I think a lot of assurance of ensuring that, for example, memos like the one issued on September 30th are followed by all local offices and not just some, will in fact be accountability. And what that accountability looks like is above my pay grade, but I support the idea.
Well, I feel like this is something to remember for us at some point in the future. We'll look at all the data which DHS has gathered on that memo, on the implementation of it, and reconvene ourselves and have a retrospective on the Jen and Shoba and Adam kind of perspective on how it went, maybe a year or 2 years later. So unfortunately, we're out of time, but this was a fascinating discussion. Thank you all so much for taking the time to be with us. I've really enjoyed this conversation. And with that, I have to say that that's going to conclude this fall's conference on the road ahead, what the president can do for the Center for Immigration Law and Policy. We have, I think, no more events as such coming in the fall, but we will have a very interesting lineup in the spring and lots of things to do in between. And so with that, I'm going to sign off, and Gabriela.
Thank you so much. This was an incredible end to an incredible half a week. We went from very micro to very macro, and we're just so lucky not only to work with the amazing folks here at UCLA, but to attract such amazing, amazing intellectuals and academics as you. So thank you so much for your time and expertise.
Take care, everyone.